So just moving forward in the agenda, the next thing on our agenda is to have a presentation from Professor Quinn from the University of the District of Columbia, David A. School of Law.
Thank you.
Please, the floor is yours.
Okay, thanks very much for allowing me to join you. And sorry, I'm somewhat late to this enterprise. I only moved back to the DMV area last year in the middle of the pandemic. And so still in some ways getting my feet under me, but I come today wearing three hats. I'm a Maryland resident. As you heard, I'm a professor of law at UDC School of Law, and I run the Youth Justice Clinic there. And third, I'm a civil rights attorney and youth advocate who for 25 years has been working on behalf of young people and system impacted persons. And I also stand in solidarity with my colleagues who've already testified, seeking to end the adultification of young people in Maryland's juvenile justice system, seeking to address direct file practices. I also stand with my colleagues from Court Watch PG, who my clinic has been working with over the last year during the pandemic to observe and learn more about proceedings in PG County. And so really that's what I'll focus on today. First, in PG County, it seems that arrested children are taken behind closed doors for clandestine initial bail hearings in direct file cases. We were quite surprised to see and learn that within a day or so of a child being arrested and direct filed in PG County, they're taken before a commissioner for their initial bail hearing. But that initial bail hearing takes place behind closed doors with no oversight, with no notice to the child's family, and without the family's presence to support the child. At least that's what we've been able to determine so far. My students and I learned about this phenomenon when we participated with Court Watch PG, which focuses on bail review hearing proceedings, which take place several days after the initial arrest. The case after case that we heard about on the bail review docket involved cases where bail, either no bail or very high bail, had already been set. And so the burden was then on the defendant, regardless of their age, to overcome that initial determination relating to bail. So we asked some questions and decided to go upstream to try to figure out how the initial hearings were being conducted. When we arrived to the jail in PG County and asked to observe those initial bail hearings, we were told no one had ever made such a request. No outsiders were allowed behind the wall of the jail to observe these hearings. And it would involve at least 3 layers of permissions for access to those proceedings. We looked for written information about the hearings so we could share it with others. For instance, pamphlets explaining the process, policies, a list of lawyers involved for young people who have their cases being heard at the jail. And we could find no such information. We ultimately filed a PIA request to simply find out how those initial bail hearings are happening for children. It's been more than 30 days now, and we still don't have answers to those questions. We were told more time will be needed to respond to the request, and it's likely that much of what we're seeking may not be available because of the way Maryland maintains information on its court computer systems, individual names of defendants, ages, and counties or facilities where the initial bail hearings are being held is not being tracked, it seems. Second, in our view, it seems like direct file, the process itself is part of the punishment, and probable cause for arrest is being used as the same thing as probable cause for irredeemability. Children find themselves in Prince George's County's jail essentially based on the word of the police officer alone without judicial oversight. The officer's characterization of the charge can have a youth, mostly youth of color, automatically direct filed into the system. But probable cause for crime should be a very different analysis than probable cause to believe the child is beyond rehabilitation. And then at the bail review hearing, some think maybe that will correct the situation. At the bail review hearing, the child might be able to then ask to have their person moved to the youth detention center, the juvenile detention center, until the transfer question is resolved. But notice the damage has already been done, and this child has spent days already in an adult jail when their case very well could have been handled in the juvenile court system as the court of first resort. Third, the bail review hearings don't fix these problems. They actually exacerbate some of the issues impacting system-impacted young people. For instance, what we saw, one, was that bail amounts, very high bail amounts, are being requested by pretrial services officials at these hearings, bail review hearings, but they are not attorneys. They appear to be unsworn witnesses, and they don't appear to be operating from risk assessment instruments, at least from what we were able to discern. We did not hear any mention of risk assessment instruments in PG County during bail hearings. But notice, if one is being used, it was likely validated for an adult and not a child, right? And so these instruments have limited features, their efficacy, they need to be geared towards a particular population. And so we've made a peer request trying to obtain information about the use of risk assessment instruments in PG County, and we still here too await that information. Bail review hearings are open to the public, so that also exacerbates problems for young people having their information made available to the public when they may ultimately wind up back in the juvenile court system. And three, as one of my students and I wrote in an op-ed to the Baltimore Sun, we're concerned about young people who could be lost in these systems. In one instance, we learned about a young person who had their bail hearing proceed through the PG County system and their case ultimately dismissed. This is a young person with mental health issues. And somehow this young person was not released when they were supposed to be, but held at least 30 days beyond the date when their case was dismissed. We've made some inquiries. We've heard that this is so, mistakes were made. There's been admissions around this problem in this case, but we're concerned that this may not be an isolated incident. And we've made another peer request to learn more about our young people, anyone really, but young people in particular being held beyond their cut dates. And here too, we've not received a response for inquiries. So that's the information that I was hoping to present, and I'm grateful for this opportunity. We're grateful for all that you're doing, and we stand at the ready to further assist if we can help your efforts.
Thank you very much, Professor Quinn. Are there any questions for Professor Quinn? Hey, Scott.
Thank you. Professor, I'm a little confused. So you couldn't find the juveniles' names in, say, judiciary case search or anything like that. Are you aware that the legislature passed a statute that made those records confidential when a juvenile is charged as an adult until the transfer hearing is held or until the transfer hearing time period is passed? That's actually a law in the state of Maryland that was enacted to protect the juveniles' records so that people can't look it up?
Yeah, so I think we're talking about two different things.
Okay.
But in response to your question, when I arrived back to the DMV, I did at one point go on to the Maryland court system's website and was able to access certain records. I was fairly certain they were for youth under the age of 18, and then those records were no longer available. But what I'm talking about isn't the documents. I'm talking about the hearings themselves. I think we agree, and I agree with any efforts to protect young people's names, information, specific facts of their cases being made available to the public if they're not already been determined charged as an adult. The thing I'm concerned about at the jail are the parents, right? Imagine you're a parent and you want to be present with your child at an initial bail hearing, right? And so it's one thing to say the public can't attend, but it appears that family is not able to attend. And I think that's a different situation. I also think, regardless of whether documents are available to the public, having done this work for 25 years in multiple jurisdictions, I've come to the conclusion that yes, proceedings involving young people should be generally closed to the public, but there also needs to be oversight. and different entities. For instance, in Missouri, the Department of Justice came to our courts and engaged in oversight practices. So anyway, I do think there needs to be access for purposes of oversight.
All right, thank you.
Any other questions for Professor Quinn? If you have your hand up and I'm not calling it, I'm trying to flip through these pages as much as I can. I don't see anybody else with any questions.
I have a brief question. I was just going to ask Professor Quinn, do you have any comparisons? I know that you just moved back to the Maryland area and you were practicing elsewhere and have practiced for more than 20 years about how our system treats children charged as adults versus the places you've practiced elsewhere. And are there recommendations or what would you like to see changed in the law if with your expertise and experience?
Yeah, so and I want to be clear, and maybe this is what the question posed earlier suggested. I'm not practicing day to day in Maryland. I'm not a Maryland licensed attorney, and we engaged in a court observation project with the clinic during the pandemic, in part because of the impediments of being in court. So I'm not as intimately familiar with the Maryland statutory provisions relating to transfer hearings and bail proceedings. Although I will say, for instance, it does appear that in 4216 relating to bail hearings, there's reference to when pretrial services makes a recommendation, it should be rooted in a risk assessment instrument, and so it does not appear to me, given my reading, that those provisions are being respected day to day. In terms of direct file, I worked in Missouri to raise the age there from 17 for direct filing to 18. And, that was a successful effort. In my experience there, it was only 17-year-olds who were direct filed. We did not have direct file in the way that Maryland has, and the numbers are staggering, the numbers that I've seen in terms of kids that can then ultimately wind up in the adult court system, essentially, as they say, on the word of the police officer alone. We had transfer, every jurisdiction uses the language differently, transfer, waiver, and we had hearings, juvenile transfer hearings on all charges. Even what we called automatic, what it meant was an automatic request was made, not an automatic into the adult system determination by the police and prosecutor. It was given the nature of a certain charge, then the prosecutor had to make the application. I will tell you, even there, I had, and in my experience, prosecutors join with us despite the requirement to make the application to say, no, this young person should remain in this juvenile court. So I think there are, I have not spent enough time reviewing challenges, statutorily or otherwise, constitutional or otherwise, that have been made to the direct file system, but I've written about this. I think there, especially post-Miller and the like, that there may be additional constitutional concerns relating to direct file proceedings.
Thank you. Any other questions for Professor Quinn? No? Well, Professor, thank you very much for taking your time today and speaking with us. Certainly appreciate your insights. So thank you very much.
Thanks for the opportunity. Bye-bye.
Right. Just moving through in the agenda, and we know that the next part is to discuss the proposed recommendations that we're going through, especially around the direct file. I believe that we received only one recommendation. Jamie, correct me if I'm wrong on that, but we received one from the Office of the Public Defender. I don't believe we received any others. Is that correct?
Right. Well, I think it was about 4 recommendations from OPD.
Okay. Yeah. I'm sorry. I was encapsulating it as one. Yep. Sorry. So with those, and I believe they went out to everybody. Jenny, do you want to talk about the recommendation, or how would you like to move that forward?
Sure, Your Honor. Sorry, I'm used to being in court.
Well, thank you very much, Jenny.
These Zoom hearings have gotten me really, I come up here and I say, yes, Your Honor, immediately. Yeah, I would like to open up discussion. I'm happy to lead or kick off that discussion, but I also think I talk a lot. So I would welcome anyone else who would like to contribute to start off and ask other people to start, because I know I talk too much already.
I certainly don't think you talk too much, but we do have the one proposal. I guess I could say.
My wife begs to differ.
Well, you call me Your Honor, so I'll give you whatever you want. Anybody else have any other proposals before we go into the proposal that the Office of Public Defender? Senator Carter, did I see you raise your hand?
Thanks, thanks, Your Honor. Also used to be.
I like this.
I like saying it.
Just I'm hoping you don't take offense.
I don't have another proposal additional, but I just wanted to suggest that we go through each one of the four, and that Ms. Egan, whoever would like to, just offer an explanation of each to make sure that we understand the distinctions and exactly what each is calling for.
Sounds great. Ms. Egan, are you comfortable with that?
Absolutely happy to do that. Sorry, let me just pull up Amy's email so I have it in front of me. So the first recommendation that I have is to end the automatic charging of young people as adults. That is pretty straightforward. That would mean that no child would have their case start in adult criminal court. For clarification, the waiver statute would still be in place. So in Maryland, we talk about transfer down and waiver up. But number one would be to end the automatic charging of kids in adult court and start all cases in juvenile court. The second part of that proposal is to end waiver eligibility for children under the age of 16. So currently we send 14, 15, 16, and 17-year-olds to adult court. I think the overwhelming amount of evidence that we saw says there are real developmental differences between a 14-year-old and a 17-year-old. So my second proposal is to end the ability to move kids from juvenile court to adult court if they are under the age of 16. The third is to end waiver eligibility for all but category 1 and category 2 crimes. And number 4 is to end the once adult, always adult provisions, which the Sentencing Project went through for us on their last presentation. That means that once a kid has an adult conviction, even if it means that they were charged with first-degree assault and they plead to a second-degree assault, that kid can't come back. That kid gets arrested for a malicious destruction. He can't come back to juvenile court. So ending that once an adult, always an adult provision. Those are my 4 proposals. Happy to talk about any of them and the contours of any of them, or flesh them out more specifically.
Yeah, so I guess I just asked, does anybody have any questions about those 4 that they want to pose? We can start just with the first one, to end all automatic charging. All kids should be started in the juvenile court. Any discussion? Scott, I see your hand up.
So my question to all of you is this. 1999, and I circulated this document, which I can do again. I put together a 40-page document of nearly 20 juveniles charged with some of the worst crimes here in the state of Maryland. But one I'll point out with starting all in juvenile court is Felix Fitzgerald, who in 1999 was a juvenile inmate at the Hickey School when he raped the nurse. Does that person really start in juvenile court? When we start looking at the 15 and 16-year-olds, or moving the date up to 16, we only have it younger for murder. And the question to all of you is, what do we do about Nick Browning? He's 15, he kills his father, his mother, his 2 brothers. He planned it, he thought it out. At the time he committed this murder, he's 6'2", 200 pounds with an IQ of 125. He knew what he was doing, and he planned it and killed 4 people. Are we really staying here in the state of Maryland that he goes to Hickey and waits while a waiver hearing is proposed, and the waiver summary is done, which now under the new case Davis has to include a tremendous amount of information, including psychological information, which in my opinion means he's going to be sitting at Hickey for at least 6 months, if not longer, and then have a waiver hearing for me to try and waive him up to the adult court. I mean, I could go over case after case after case. Are we really saying that Lee Boyd Malvo, who executed 5 people, should start in the juvenile court? I mean, I could go on and on and on for cases from all over this state where, you know, we're now going to say, all right, if we pass number 1, all of these people start in juvenile court when they've committed some very adult crimes. I just can't see how we can really honestly can consider that proposal. Look, I get it. You know, there are places where I can get to, you know, maybe, you know, Miss Egan's example is a good one. And, you know, maybe if you're, you know, you get a conviction for a misdemeanor and you're still 16 or 17 and you commit another misdemeanor, yeah, I could live with that one, the example that Miss Egan gave. Frankly, of all the offenses that are listed in that statute, I could probably live with simple possession of a handgun starting in misdemeanor court. But even when you get down to things like third-degree sex offense under 3307A1, which is listed there, that is sexual contact. That means somebody has touched an intimate body part, either using a weapon or aided by another, or strangled the person or threatened death. I mean, are we really saying that 16-year-old should not start in a more secure location when they've committed a crime like that? And of course, I could go through them all: first-degree murder, abduction, kidnapping, second-degree murder, second-degree rape, which involves force, robbery, carjacking, use of a handgun during a crime of violence, first-degree assault. We're going to start all these folks in juvenile court and then wait while we try and waive them up. I can get to a couple places.
So can I
I lost Dr. Simmons, but I can see where we can get to a couple places on some of these, but not on the biggies.
Glenn, you're muted.
That's usually where I do my best work, muted. I know Delegate Pippy had his hand up, but I know, Jenny, you want to respond. Delegate Pippy, you want to go, or?
I'll be real quick, and then Ms. Egan can chime in. I mean, I think Scott brings up a point, and I'd like to see these written out. I mean, you know, these are somewhat blanket policy changes, and maybe everyone on the call is familiar with all the delineated offenses that this would fall under. But I think we should see it written out. I mean, what offenses are we talking about? And, you know, maybe there is a middle ground where, you know, there's a place that we could all get to. But for some of these really egregious offenses, I mean, when you read these policy changes, it doesn't tell the whole story. I'd like to see the actual offenses that this would change. And if there was a separate email sent out that had all these listed specifically, that would be helpful. But I think it's important to talk about it because, I mean, look, people's maturity levels are different. I mean, I know there's an argument that people aren't fully developed until they're 25, but there's also balancing that with public safety. I mean, if you have somebody who's, you know, 15, 16 that's killed people, I mean, that's an important public safety consideration. So regardless of how old they are, for that matter. So just piggybacking on what Scott said, I'd like to see, you know, what these charges are specifically. Every single charge that would fall under this, I'd like to see it written out. So that's all I have. Thank you.
Thank you. Ms. Egan?
Nate had his hand up, so I'm deferring to the.
Nate?
Yeah, thank you. I think I know this is going to be a discussion and there's lots to break down with this, but I think Mr. Schellenberger's comments, there seems to be two different things that are being talked about, and I think it's important that we're clear on them. We're talking about where a case is in court and where a young person who is accused of a crime would be held. And I think we're conflating those two things and we're talking about them together. I'd like to understand from DJS how it works now and understanding federal rules that would put the state of Maryland into compliance about where young people are held, irrespective of whether their case is being tried in criminal court or in juvenile court. The young person is under 18 years old. But my understanding is right now, when we are starting all of these cases in criminal court, in much of Maryland, if not most of Maryland, young people are still being held in DJS detention centers right now. So the example that's being given, that is the practice right now. The question is where the court jurisdiction is. And I want to go back to that later, but I wanted to ask this question now because I think it's an important one for us to understand that when a young person is tried with murder in Maryland, they're being held in juvenile detention centers, is my understanding for the most part.
No, that's not true. So you are correct for the majority of juveniles, say a robbery or things like that. We have to follow the Supreme Court guidelines on where they're held, and it's usually in a juvenile facility. But there are exceptions, and there would be no exceptions if you change the jurisdiction. So an individual like Nick Browning, if he's charged as an adult, if we prove the right things, could be held in the adult system. And Glenn, I just wanted to let you know that for Delegate Pippy, if you let me share my screen, I actually have a list of those crimes if we want to get into that much detail today and go over those.
Okay.
Or I can just try and send an email out. I'm not very good at this, but
Well, if I could, Glenn, I'd like to address the question that was directed to DJS about the housing issue, and I can answer that, and then happy to defer to Scott to share the offenses. But generally speaking, yeah, we do house kids charged as adults. As Scott said, there are exceptions to that and allow for youth to be held in adult facilities within the Maryland law. However, the federal law has changed, and the federal law requires the juvenile agency in each state to house youth, whether they're charged as adults or not, up until their trial date. That includes everyone charged as an adult. So while it is not in Maryland law now, we are currently in violation of the federal law as a result of that. And then just in terms of, sort of operations, the questions sort of come up from time to time, whether we have space to accommodate the population. We do. And whether we are, geared to serve this kind of population, and we are. I know we never were able to do a tour of a facility, but we could certainly happy to have anyone come and see any of our detention centers. But when we're talking about detention centers, these are not the same as the youth centers that are not secure. Our detention centers are secure. They're hardware secure facilities. They have steel doors, just like you would find in a jail. Kids are housed in individual rooms. And so in terms of the safety and security, we do have the capacity and expertise to manage that population.
Thank you, Secretary Bed. Ms. Egan, did you, I think your hand was up at some point.
It was, but Senator Smith was up before.
All right, I'm not following all the hands, sorry. And I don't know if everybody else is, but you guys are all jumping around all over the place on my screen. I don't think it's anything you're doing to my screen, but I'm having a hard time tracking you. But I see Senator Smith now.
Hey, well, thanks. I appreciate it. Nate synthesized my questions more perfectly and appropriately than I could have. We're going to get after this pretty early in session coming up. And for Secretary Bed, I definitely want to, planning to see as much as I can in person before session starts. So definitely take you up on that. But if the committee could produce and kind of streamline this process for us as we, head into the session, that would be, I think, a huge value add and really informative for our discussions as we move forward. So Nate hit that, the nail on the head for me. I would just say that when we come out of this work group, it'd be great to have that process kind of streamlined and outlined for the committee and for the General Assembly to consider as we head into session.
Glenn, I emailed you the list.
Okay.
If you want it, I emailed it to you.
I will share that with Jamie. I don't think they don't give me permission to do anything. I can't chat. I can't do anything. So I'll send it to Jamie. Ms. Egan, I'm trying to get you in. I don't know if it's your turn yet or now.
I actually think it's Dr. Sickman and then me.
All right. I'm going to let Ms. Egan run the meeting.
I'll let her pick the order. I mean, just a comment that occurred to me as you all were discussing, especially Mr. Schellenberger talking about past cases. When you're talking about past cases like that, you're talking about individuals who a court, whichever court it was, has decided that they were guilty. When these cases come to court, every one of those individuals is not yet guilty. And so what they're charged with might be very serious, but at that moment, it's not known whether they are the guilty party or not. And so I think we have to keep that in mind. And I just, I work for an organization of juvenile and family court judges, and I personally feel a lot more comfortable with having the process start in juvenile court being an individual case-by-case decision-making process rather than a legislatively decided all these kids will go to criminal court or prosecutor decided. It's an appealable decision, and there's some advantages in that.
Thank you. Ms. Egan?
Thank you. So I wanted to address the proposal itself on its own grounds, and then I can address some of the things that Mr. Schellenberger raised. I just want to raise that we have had many hearings and many witnesses, lots of documents and testimony, and we have not had any evidence presented that says that automatically charging kids in adult court protects public safety. In fact, all the evidence presented before this council shows and proves that it does not. So when Delegate Pippi says that this is a balancing between the needs of someone who, as Dr. Sickman reminds us, is presumed innocent versus public safety, I would point that all the evidence presented to us by every expert says that charging kids in adult court makes us less safe. The CDC, the DOJ, the JDPA, doctors, research, meta-analysis all say that the same kid for the same crime tried in adult court is more likely to go on to commit further offenses and to be a greater risk to the public safety. So if we are balancing the risk to public safety, I think that the evidence falls squarely in not charging kids in adult court. If public safety is what we want to protect, we must end automatic charging of kids in juvenile court. Second of all, there was talk by both Mr. Schellenberger and Delegate Pippi about balancing or political horse trading. This commission is tasked with making a recommendation based on the evidence. And the evidence presented to this commission has been overwhelming that Maryland's system is too broad, that we charge way too many kids as adults, that it doesn't protect public safety, and that it's operating in a racist manner. 80% of children being sent to and charged in adult court are Black in Maryland. And almost 90% of them, I think it's 89.6% of them, do not end up with an adult criminal conviction. That is an untenable system that is racist, I believe was racist in its original intent and is racist in its application today. We need to end it for a number of reasons, but those are my main arguments. As for where the kids will be housed, as Secretary Abed pointed out, federal law says all kids charged need to be in juvenile facilities, and Maryland is going to have to bring itself into alignment or lose the majority of a huge chunk of funding for juvenile justice reform. So that question isn't before this body, is not what we're negotiating. And also that ship has sailed. Maryland already passed a bill to end housing kids in adult facilities for the vast majority of kids. In fact, in Maryland, almost exclusively, there are kids being held in adult facilities in just a few counties, Mr. Schellenberger's being where the most kids are in adult facilities. I would note that kids in adult facilities are more subject to sexual assault, more subject to physical assault. They don't have access to education. And I have reports that at the Baltimore County Detention Center, since we changed the law and stopped housing a huge number of kids there, there is no longer a dedicated youth tier with active supervision by correction officers. That means that children who are housed in Baltimore County pre-trial, while presumed innocent, as young as 14 and 15, means their movement is even more restricted. They can't sit out on the tier. They're locked in their cells for large parts of the day, and they cannot have any of their psychotropic medications, even with pre-existing prescriptions. So we have children who often are developing mental health disorders, whose schizoaffective disorders are blossoming, which often leads to youth crime. And yet when they're held in adult facilities, they don't get proper schooling as required by federal law. They don't get access to medications, and they certainly don't get the services and supports that they would in juvenile facilities. All that to say, that's not the question on the table. The question is, where should these cases start? And my question back to Mr. Schellenberger is, given those 30 or 40 cases that go back more than 25 years, if that's the handful of cases, why does starting them in juvenile court not make more sense, given that we've charged 7,800 kids in adult court since 2013? If there are less than 24 on a parade of horribles, why are we sending all our kids that way?
Well, I'll bring it up to date then. 5 days ago, I had a 15-year-old who killed his father. So that just happened. That's not 30 years ago. That's not Nick Browning, who was 10 years ago. That was 5 days ago. 15-year-old shot his father to death. What am I supposed to do with him? Is he really supposed to be treated as a child for the rest of the time? And anyhow, so Dr. Sigmund, remember those individuals who are being held have had 2 judicial hearings. It's not just a police officer deciding. They have to go to a commissioner and show probable cause. At the commissioner's hearings, under the Richmond case several years ago, a attorney represents them at this bail review in front of a commissioner. Commissioners don't work for me. They work for the judiciary. They're judicial officers. If that commissioner doesn't let them out, then within 24 hours or the next court day, which candidly, when it falls near Labor Day, they will be staying in a few days, there's another judicial officer, and that's a judge, who will hold a bail review hearing. That is one in which the parents and friends and other people can come. And again, there's a public defender who represents the individual, or private counsel. So, I mean, these folks are getting due process, and it's the exact same due process as adults get. The only difference is, if they're under a certain age, I have to act faster. Instead of trying to charge in 30 days, I might have to charge in 15 days. So there are so many things in place that change and accelerate the system for those juveniles who are charged as adults. And the other thing that's happened is, as I indicated, Senator Carter and several of the legislatures have over the last few years built in protections. So if it is one of those cases that gets waived back, then there's the ability that the public doesn't see any of those records. They've passed all those laws now that are going into effect. So I'm trying to find out, again, nobody has answered the question, what do I do with Nick Browning?
Thank you, Mr. Schellenberger. I think Delegate Pipke, you were next, then Senator Carter, Mr. Ford, and then Senator West. Delegate Pipke?
Yeah, real quick. I mean, before I make a decision, as an elected official, and we have to vote on things like this, I try to look at both sides. I try to get the whole picture I think I have a history of working on a lot of bipartisan bills, a lot of bills getting a lot of input from different parties. I would want to know, why are there automatic charging as juveniles as adults for certain crimes? We haven't talked about that. You know, why was that put in place in the first place? I mean, I would love to have the luxury of literally just opposing any public safety bill that comes before, which sometimes I get the impression that the public defenders, that's exactly what they're doing. But I don't have that luxury. I've got to look at both sides and make a decision objectively. And so, you know, why were these laws put in place in the first place? You know, what was the decision back then? I mean, when you decided to charge a 16-year-old who's committed first-degree murder as an adult, why did they decide to make that a law? You know, we haven't talked about that. It's easy just to throw out, you know, the baby with the bathwater, but, you know, I don't have that luxury. So I again, you know, we're talking about a blanket change, and we don't even have the list of the egregious offenses kind of before us, you know, as we're talking about. So maybe Ms. Egan can address that. I mean, what's the history behind it?
I'd be happy to address that history. We do have those lists of offenses. We've had innumerable amounts of documents and briefing, which are all available on the DLS website. I'm happy to have Jamie drop that link, but we have the list of offenses, the categories, the percentages we've gone over ad nauseum and in depth in this meeting many, many times. The history of charging kids as adults in Maryland is outlined most recently in the case Scott Schellenberger references, which is Davis v. State. The process of charging kids as adults started out with a racial difference. So kids started being charged as adults automatically at the age of 16 if they lived in Maryland, or if they lived in Baltimore City around the turn of the century. It was 18 if you lived in the rest of the state. Those laws then were accelerated in the 1970s, and then it really kicked into gear, and we started charging more and more offenses and younger ages with people, with young people in the 1980s, based on the myth of the super predator. So the super predator was a racist myth perpetrated by a number of criminologists who have since apologized and retracted their statements, but they basically tried to use the poverty and oppression of Black people to say that there was going to be a wave of crack babies who were going to be super predators, children who were preying on us, carjacking people and killing people because they had no conscience. And there was a concerted effort to portray Black children as subhuman or less than human. And that's when the majority of these laws were passed, including the 1994 crime bill in Maryland and federally that added the largest number of offenses to youth charged as adults. It is a history of racial inequity, injustice, and racism that has led to this practice.
Thank you, Delegate Pipke. Thank you, Ms. Egan. I think Senator Carter was next, and then Mr. Ford, then Senator West.
Thanks so much, Chair Houston. So I think I'd like to start by answering Scott Schellenberger's question. What does he do with a case like Browning? I think the answer is very simple. You bear the burden as the state's attorney to make your argument that in this case, this child should not be treated in adult court, and then you leave it up to the discretion of the court to make that decision. But as has been stated, to have a system where an officer at the officer's discretion can make a decision about what a charge is that could make the difference between whether a child starts automatically an adult or not is problematic. And even as you talked about the process that ostensibly has due process and some checks and balances, what we know is that those hearings before commissioners give the commissioner zero discretion to move a child into juvenile court. The later bail review, if the child is then held, that judge does not make a decision about whether or not to move the child back into juvenile court. That hearing comes much later in the process. And so there is this incredible time gap between what that happens. And even though we're making steps to make that more efficient, we still haven't addressed the fact that based off of oftentimes an officer's discretion, this child is already held there. I think that Ms. Egan makes the strongest case, but not because of her, but because she talked about the numbers. She talked about the numbers since 2013, over 7,000 children automatically charged as adults, less than 11% or about 10% ultimately convicted as adults. We're destroying lives. We're destroying the lives of those children. That is the reason that we have to do it differently. And we talked a lot about what's been presented to this council. I want to just point out that this isn't new stuff. We had a commission back in 2013. Secretary Abed was a part of it. It was to address this issue of juvenile court jurisdiction. Secretary Abed made the case then and makes the case now that he has the ability to house these children. We fell short of making the decision, the courageous and right decision we should have made then with stopping automatic charging direct file. And it's time for us to do it now. And so I won't belabor the issue because I'm sure there's going to be more discussion, but I don't think there's a real legitimate question about what you do with that one case or a case like that. We aren't talking about whether or not that person is going to ultimately be convicted. And as the doctor said, we're talking about, Dr. Sickman said, we're talking about, I don't understand why we get away from the fact that everyone is cloaked in a presumption of innocence at the beginning of a case. So not only does it have to be some proof that the charges actually will stand, they have to meet a probable cause standard, but then they have to meet a reasonable doubt standard. And so what we get at the beginning of a case, we are legally not allowed to presume guilt at the beginning of a case, and we shouldn't do that. So for all those reasons, we need to move forward on this. And frankly, it's long overdue because those 7,000 children, since we've had the evidence, have suffered because we have failed to act in the past.
Thank you, Senator Carter. Mr. Ford.
Yeah, thanks, Glenn. So yeah, I just wanted to, try to put this in perspective because, I think at whatever point in your career, all of us on this call, we view each other as advocates in this work. We're advocating for people. Sometimes that happens before arrest, sometimes that happens during arrest. And for some of us, we are advocates throughout, before and after an arrest. But I wanted to stress that there does not have to be an arrest for there to be a victim. So many of the youth that commit these crimes, some of the ones that Mr. Schellenberger has brought up, they're also victims of crimes. They've been abused, they've been neglected, and they're victims of trauma. I mean, what other reason would a person commit a crime so heinous other than that they have been a victim of abuse themselves, or they have a mental illness? So, we should consider their best interests and ensure that they have the support they need by putting them in juvenile facilities and that they're not further victimized in adult facilities. Secretary Abed has assured us that his facility is just as secure as an adult facility. And if there's data or information that shows that his facilities aren't as secure, then that should be presented. But all we have is the information that he gave us. So we should trust the Department of Juvenile Services that they can provide the security that's needed. And then, I work with Bill Harper, who's our compliance monitor. He works out of Glenn's office. I work with him as a part of the state advisory group. He has said that the staff in these adult facilities do not want youth in these facilities because, again, of the capacity issues that it creates for them, the staffing issues that it creates for them to keep them separate. So we're also looking at a financial issue as well, and a compliance issue. So, it's real important that, again, that we look at the young people who have committed these crimes as victims themselves. And I think everybody, on this call will say that they are an advocate of victims. It's just how and when we decide on when that victim takes place.
Thank you, Mr. Ford. Senator West.
Thank you. So let me just preface this by saying, even though I'm a lawyer, I've never practiced criminal law. And I don't know much about criminal law, the ins and outs of it. I certainly don't know much about juvenile justice, the ins and outs of that. My concern here is that there may be collateral consequences for our agreeing to some of these recommendations. We've talked mostly so far about where the young perpetrator is going to be housed between the time he's arrested and the time there's a trial. And I think I've gotten a fair amount of information about that. I got two questions that just stand out. Number one, what is the standard that must be proven by the state's attorney in order to waive someone up into adult court? And conversely, what is the standard the public defender must prove to move someone back from adult court to juvenile court? Are they the same standard? Are they different standard? Is one harder to meet than the other? And then secondly, and maybe more importantly, what is the length of punishment for a person convicted in a juvenile court of some of these long list of crimes versus what is the length of punishment for a person convicted of the same crime in the adult court? Are they exactly the same? Are they different? There's been no information about that. And I think I know I would need to have that kind of information before I could cast an intelligent vote on these issues.
Great. Thank you, Senator West. Nate, I believe you are up next, or Mr. Ballas, sorry, and Delegate Pippi, and then Ms. Chapman.
Yeah, and I don't know if someone wanted to answer Senator West's question, because they seemed like they were, Senator West, was directed at anyone that you wanted to make sure I answered that before we move on?
I guess anybody who feels qualified to answer. Scott Schellenberger looks like he's off screen. He probably could answer the questions. My guess is that Jenny could answer them too. Maybe there's some others.
Yes, so is there anybody that wants to? I'm sorry, I took that more of as a homework assignment.
Well,
if we're going to vote on these questions today, I hope we can get my questions answered before the vote.
Senator, I can give you some of your answer, and I'm sorry, Jenny, I didn't mean to interrupt. I just wanted to give a response. In terms of the second part of your question about punishment, the juvenile system doesn't have, a system of punishment. We do have a length of stay, and that is limited to age 21. So there isn't really an analogy there. The length of stay is set by the court, and the court has, their discretion up until that age. But typically, kids don't stay. They stay 6 months or less in general is our average length of stay.
No, wait a minute, Sam, could we stop there for a second? So if there's a young person who is 6 months shy of his 18th birthday and commits a first-degree murder like the one that Scott mentioned happened a couple of days ago, are you saying that if that person is convicted as a juvenile, that person will be out of jail and walking free when the person turns 21, as opposed to getting convicted in an adult court and perhaps going to jail for a considerable period of time?
So if the conviction, if you're talking about conviction, if the adjudication took place in juvenile court, yes, at 21, the jurisdictional limits would end. But I think the question that we're addressing here is in which jurisdiction initially should those kids start? And so the issue between starting in juvenile court versus starting in adult court would not get to the conviction or the adjudication piece. It's really about where should the case start, and should it start in the adult court and be transferred back, or should it start in juvenile court and have a judge decide whether it should be waived up? And then if the case were to stay in juvenile court, whether it started in adult or it started in juvenile, that limitation would certainly apply.
Okay, well then that triggers the first part of my question, which dealt with the standards for waiving it up or the standards for bringing it back down. Who can talk about how hard it is to waive a case in juvenile court up to adult court? And by contrast, how hard is it to take a case from adult court and put it back in juvenile court?
So just as a matter of law, in order to transfer a case down, the court must find by a preponderance of the evidence that the child is a fit subject for juvenile rehabilitation matters. And in looking at that, the court weighs 5 factors: the age of the child, the mental and physical condition of the child, the risk to public safety, the nature of the offense, and oh gosh, I'm nervous. So I'm in chart. Scott, what's my number 5? Why am I missing it? Oh, and whether the amenability of the child to rehabilitation. Amenability is the sort of under Davis v. State, the decision that came out last month is sort of the crux. that all the other ones hang on. But those are the 5 factors. In a transfer hearing, the burden is on the defense to prove by a preponderance of the evidence. And in a waiver hearing, the burden is on the prosecution to prove. And those are the basic mechanisms.
And Ms. Egan mentioned the Davis case. So there was a very lengthy, I think it's 35 pages, opinion by Judge Wilner, I believe, where he outlined what a juvenile court has to factor in. And while they may call it 5 factors, which is what we've been calling it for 20 years, Judge Wilner put a lot in there, particularly the part about amenability to treatment, and actually felt like the judge should have considered more at that particular waiver hearing. So I think this is a burden that's changing. Not the burden is changing. Ms. Egan's right. It's preponderance of the evidence. But this is a factor that's going to be way more than 5 factors now that there's a new case from the highest court in the state. And it just came out a month ago. It's very extensive. So I think a lot more has to be considered than those 5 things.
Well, let me just pursue this briefly, and then I'll shut up. So let's take Scott's case that happened 5 days ago. A young man, a juvenile, murdered who? His father? Yes. Okay. Murdered his father. So the question is, where's that case going to be tried? If it automatically were to go to juvenile, isn't it likely that the state's attorney would try to waive the case up into adult court, claiming that if it was a first-degree murder, and if it stays in the juvenile system, when the person assuming the person gets convicted and gets put in a detention facility, it will be for a very, very brief stay, and then the first-degree murderer goes free. And therefore, the case ought to be moved up to the adult court, because the appropriate punishment is not a brief stay in a juvenile facility, but rather an extensive period of confinement. Am I right on that?
That's correct in some ways.
The judge's opinion be affected
the child's
by that
15
argument?
and 16.
I'm sorry. Go ahead.
So I think that's what we're arguing, and that is the crux of my recommendation, is that right now we have almost 1,000 cases a year, and just to be clear, the vast majority of them are not first-degree murder. The vast majority of them are handgun possession and first-degree assault. But aside from the fact that we're focusing on the smallest percentage of cases that are non-representative, second from that, yes, the state's attorney could waive them. We think that's a more appropriate process for the child to start in juvenile court, for the transfer decision to be made by a judge sitting in juvenile court, who there are requirements for judges in juvenile court to have special dispensation and training and understanding of juvenile law and juvenile adolescent development. So yeah, that's the argument, and that's what would happen. I think that Mr. Schellenberger was the first one to say in our last meeting on this topic that of all the cases he cited, he thought he would have no problem waiving any of them up to adult court. So if the vast majority of these parade of horribles would be waived anyway, the argument is there are 980 other kids who are being charged in adult court and having their cases transferred down, dismissed, or otherwise not being convicted, that are being horribly mistreated and having their lives disrupted in ways that make us less safe, right? That lead to worse public safety outcomes, and that have led to us having the highest percentage of Black people imprisoned compared to any other state in the nation.
And Jenny, you know, I gave you the possession of handgun. So you're saying there's 1,000 and half of them are possession of handgun. That was my first statement. I said, I'll give you that one. So we can walk away and fix half of this problem right now by just that concession. So, you know, and it's not, I mean, it's a parade of horribles that I put together by just sending out one email to state's attorneys across the state. I believe there have to be more. I mean, in fact, there's another one, and that's pending in your jurisdiction. And that's it was in the paper today about a man who was killed in Fells Point and there was a write-up in the paper yesterday or today. So it's not 20 years ago, and I gave you at least 500 cases that we can start in juvenile court.
Absolutely. My argument is not that. It's that those are the smallest percentage. They are not representative in any way, shape, or form. And federal law mandates that we have to change the law or we're going to lose all our funding to house all those kids in juvenile facility. And two, all the evidence presented to this council says that even those children who commit the most horrible offenses are better off in a juvenile system. I will note that in this parade of horribles, we keep talking about children that have assaulted their families. We must remember that adolescence and late adolescence, especially for young men, is the time that the most disruptive mental health disorders come to bear, right? The fact that a child didn't know they were schizophrenic and didn't know or understand that they're hearing voices. My clients hear voices and they are 15. My clients and some of the people who Scott lists in that document were horribly, terribly tortured and abused. When are we going to hold the adults accountable? And when are we going to hold the systems accountable for what we do to our children? These are not hardened criminals. They are kids. And yes, my argument is for someone like, I forget his name, Nick Browning in Baltimore County. My answer is what you do with Nick Browning is you file your motions, you argue your case, and you put on a case. And in the meantime, federal law says he should be housed only with kids, that he must have sight and sound separation from all adults. And if you put on your case, the state will win by a preponderance of evidence and he'll be tried in adult court. Why are we wasting hundreds of millions of dollars throwing 90% of the kids who are charged as adults do not end up in adult criminal convictions? Why do we continue a costly, broken system that makes us less safe?
So Scott, I don't know if you want to respond to that very quickly, but then I'm going to go to Mr. Ballas, Ms. Delegate Pipke, and Ms. Chapman.
Well, it's not just Nick Browning. Eric mentioned that, a lot of these young people are broken, and so did Miss Egan. What about Lewin Powell? Lewin Powell beat his mother to death at the age of 16. He was an honor student at McDonough. I mean, I could go through all of these. I understand they have mental health issues, and we should deal with that at the lower level. But when we're talking about these kind of crimes, and that is carjacking with a gun, murder, kidnapping, rape, I mean, this is just a whole different category. And again, we can go through the 33, and I've just given you one that's going to get you 500 cases. Maybe there's another one on here. Although I got to tell you, somebody asked me yesterday about third-degree sex offense, and that's sexual contact with a weapon. I mean, I don't know. I can't give that one up. That's where I am.
Thanks, Scott. Nate?
Yeah, thanks. And thanks for those answers. I kind of want to go back to both, I think, Delegate Pippe's question earlier and just, go back to why we're here. I think Delegate Pippe asked a good question about the history of this, and I really appreciated Jenny's answer. But I can assure you that when Maryland was making its decisions in the 1990s, like virtually every other state in the country, and made it easier to try kids in criminal courts instead of starting them in the juvenile justice system, they were not following the charge of this Juvenile Justice Reform Council, where we are being asked to look at the evidence, look at best practices, and look at mitigating future offending. And everything we've heard to this point tells us that the practices of Maryland today fly in the face of all of those things when it comes to the way we use direct file. And so I want to start there for a second. And I want to make the point, I think I imagine my colleagues here at the last meeting was alarmed when the Sentencing Project put up on the screen the chart showing Maryland's rate of charging kids as adults, and that we were second only to Alabama in the entire country. That's what we are now. That's what the current laws as they exist now, and the putting the burden on defense to bring the case back down to juvenile court has done. It means that we are starting all of these children in criminal courts, and whatever happened in the 1990s in creating these laws and the hundreds of books that have been written since then and articles about why that was such flawed thinking and so broken as a country of the way that we did that and the way we have specifically impacted youth of color and Black boys in particular through those laws. In the last 20 years, how much we have learned about why that's wrong, about why those practices are wrong, about what we've learned about adolescent brain development, but what we've learned about alternative approaches, about what we've learned that the juvenile justice system can do. We've learned, and other states have responded. That's why we stand where we are. So we are behind. And there are so many ways in the practices right now in Maryland, in the system, the practices of the juvenile justice system are doing real good, like are really moving ahead, are changing the way that the system is working in Maryland. But in this particular way, we're not. And it's not just that we're behind a current trend, we're behind a trend that's dangerous. It's dangerous for the young people who are being charged as adults, and it's dangerous for community safety. As we've seen, the evidence tells us this way. And I think the only question that we're really talking about is given everything we know about young people and how they're different from adults, where should the burden lie? Should the burden lie with young people to prove that they're children? Or should the burden lie with prosecutors and the courts to show, nope, this is an exception. This is bad enough. It's the ugly cases that Scott Schellenberger is talking about and saying, nope, too much for this one. We need to try this kid in criminal court. That's the question before us. And I just think we should strongly lie with the evidence and with the idea that the burden should be to show why a child shouldn't be treated as a child, not the other way around.
Thank you, Nate. Delegate Pippy?
All right, I'm going to try to just succinctly get this out, and then I'm going to try to take a break because I pace myself here. So a lot of things have been mentioned. I
think you muted.
Delegate Pippy, you went on mute.
Okay, I'm muted now. Apologize. I'm going to try to just do this as succinctly as possible. We talk about how the juvenile facilities in this argument would be adequate to handle this situation, but yet I want to remind everybody that I want to say a year ago, 18 months ago, Ms. Egan, as one of her recommendations, literally wrote down that we wanted to close all juvenile facilities in the state. She wrote that down as a recommendation. And matter of fact, Senator Chris West and I had to bring that up as to why in the world would that be written down as an official recommendation from her. Second, the only hardware secure facility in this state is in my legislative district in Sedillisville. And there was a riot there where 7 juveniles overtook the facility and seriously injured a bunch of the workers there. I'd be curious to know if those individuals were charged as adults and held at a juvenile facility. I know Sam probably doesn't like to reminisce about that instance, but that was a serious situation where the kids, as Miss Egan would call them, I think they were 17 at the time, literally overtook the facility and injured staff. So is that the adequate facilities that we're talking about? That's a real life event. That's evidence-based. That's not the rhetoric that we keep hearing on this call. Second, we talked about handgun offenses. I want to remind people that in Miss Egan's city, where she lives, has the highest murder rate, actual murders occurring in the country per municipality, has 700 plus shootings a year. And I want to remind everybody that the state's attorney there testified in front of our House Judiciary Committee that 80% of those were all unresolved, all unsolved. So the idea that we would just dismiss handgun violations as, oh, that's not a big deal, where our major metropolitan city has a major issue with it. And we need to have results. We need to work with that municipality to solve that issue. That's a priority. And back to Eric Ford's point, because he was asking, have there been any instances to go by? Well, the Victor Cullen's a real life instance. It's the only hardware secure facility in our state, in my legislative district, and the juveniles had a riot there a couple years ago. So I want to point that out. Another thing, about administering medication. Mental health is a real issue. And I actually put in legislation a few years back to address mental health with youth. That's an important issue for me, and it's real, and it does impact and cause a lot of people to go down a life of crime, and we need to address that. And so if there are facilities in the state that are not administering medication when an inmate has a diagnosis, we need to address that. But I'm not going to, again, throw out the baby with the bathwater and make an argument, oh, they're not administering medication, therefore they should all just go down to a juvenile facility. That's ridiculous. That's a ridiculous argument, because we could address that. We could address that with the Department of Corrections within our state. And then the last but not least, I think it was President Joe Biden who passed the 1994 crime bill. It was his bill, literally. You know, so I'm sure I'll have more. I'll take a break, but I just want to separate the rhetoric from what's actually happening down the street. And Ms. Egan, I mean, this is, these are serious issues here, and I prefer less rhetoric and more facts. And I do appreciate the history of charging juveniles as adults, and that there are some racial implications there, and that should be a factor. And I can sympathize and appreciate that, and I appreciate you giving that history. But for some of these other things, let's stick to the facts and put the rhetoric aside. Thank you.
All right, I know that we have Ms. Chapman, then Dr. Sigmund, and I saw Ms. King-Johnston raise her hand, and then I think Ms. Hardy is after that. So thank you very much. Ms. Chapman?
Yes, good afternoon, everyone. So I'd like to thank Delegate Pippy, because he made my point exactly. I think the quote is, insanity is doing the same thing and expecting a different result. I think everything he just said, we cannot keep doing the same thing. We can't expect to keep, putting our young people, direct filing them into the adult system, them not being treated, and expecting that they're not gonna, their trauma won't be exacerbated, they're not treated, and that they're not gonna come out and not do the same thing, but actually do worse things, and public safety be, at risk. And so, we see that happening. And so I think, you speak about, rhetoric and all of those things. We've had a massive information. Nate spoke to it. Jenny, others have spoke to it. We've had a lot of best practices, a lot of research that has been presented to us that speaks to what we should be doing as a state. We are way behind the game. To be second to Alabama, it's sad. Alabama is a state that still has sundown towns. If you don't know what that is, look it up. I don't feel safe driving through Alabama. And so we should be aspiring to be leading, not even following, because at this point we're a follower. We should be leading. And so we want the best as a Juvenile Justice Reform Council. We should be looking at what is the best for our young people and what is the best for the citizens of Maryland. And right now, as far as, where we are, the young people we're speaking to, what I'm hearing is we're speaking to kind of a small percentage of cases who essentially they'll end up in adult court. But again, as many have said before, there's so many more, almost 1,000 young people who could be not just put into adult court who are not equipped, in adult jails, they're not equipped to treat young people. They don't want young people. At the federal level, we've been told that we need to put them in juvenile court. We're going to lose essential funding that will help to support us to be able to work, on the prevention programs, to help with intervention programs. We don't want to do that, because if we lose that funding, we're just kind of basically we're going to have more juveniles that will be going down that route. And so, if we want to look at ways that we can help to intervene with those who are at risk, we need to be looking at how can we funnel those young people who didn't even end up, we heard the stats before, 10% that ended up essentially in adult court, those who never even ended up in adult court. How can we, and those are tax dollars that we're wasting. Adult jails, all of that is expensive. So we're spending tax dollars that we don't have to spend and all of that too, while young people's lives are being destroyed. And so, you know, we talk about structural inequities all the time. You know, equity has been kind of the buzzword since everything has happened. Is we're positioned right now to do something about it. And so not just talk about it, but really to do something about it. And so I hope that we all understand where we are right now, how this is historical, how we're positioned, and that we do something about this for our community and for our young people.
Thank you. Dr. Sigmund, and then it'll be Ms. King-Johnston, and then Ms. Handy.
I just wanted to remind folks of you know, some of the presentations that we have had before, talking about the changes that have been made in other states that have been ahead of Maryland. So states like California that fully eliminated their prosecutor direct file provisions that were put in place in the late 80s, early 90s, to have a waiver only, everything starts in juvenile court process. I find it hard to believe that Maryland thinks that it's got more tough kids to deal with than the state of California, County of Los Angeles, and just the greater population that they have. You have states like New Jersey who have also put in place similar minimum age restriction of 16. We can pull together that statutory language if that's helpful for the legislators. You know, we have had this on the table for a while in terms of examples from other states. So it's not like Maryland is out there on its own doing something that no one else has done before. It's been done, and, you know, talk to the people in those states, see how it's going.
Great. Thank you, Dr. Sigmund. Ms. King-Johnston.
Yay, I unmuted myself. Hey, it's a big thing for me. I oftentimes disconnect myself, so this was good. I just have a statement, and then I do want to take a point of personal privilege. It appears to me, based on everything I've read and everything I've learned from the people in this room, as well as from Secretary Abed, who I've worked with for many, many years, Mr. Schellenberger, who was my seatmate at the original part of this JJRC. We have had great discussions and great conversations. We do not always agree. What I will say is that it is my opinion that automatic charging, the way that it is in this state, is inherently discriminatory, and that by eliminating automatic charging, we still have the same options. If kids start in a juvenile court, they can be waived up to the adult court. It just gives us more options. It doesn't really take anything away. And then for my point of personal privilege, I've been involved in this commission since the beginning. I've been involved with other DJS things, and I'm an educator, also a parent. And I just want to say, we have managed over the last few years to have these very serious discussions. We have managed to come up with good recommendations, some of which have been adopted by the legislature and some that have not. But I'm very concerned about today. I think that to try to characterize people trying to give their opinions based on the data that we have all had and received and seen over the last 2 years or so, and maybe over the last 10, to characterize it as sarcastic or rhetoric or name calling is a big disservice, not only to the people sitting here today, but to our legislators, to the children and the parents who we serve. So I would remind us that while these are hot topics and each of us is touched by it in one way or another, we really need to get back to the business at hand and not really do this name calling, finger pointing, because I think that in the long run, everyone wants what's best, and we just have to figure out how to get there. So thank you for letting me speak.
Thank you very much. Ms. Handy.
Good afternoon, everyone. Thank you for allowing me to be on the task force. I wanted to share a bit of a personal experience as well as explain to you guys how I'm feeling right now. I am a former, I guess you would say, juvenile that was charged with second-degree murder, first-degree assault, and second-degree assault. I'm shaken right now. Delegate Pippi, your statements They hit me to the core and they hurt me. They hurt me a lot, considering not calling kids kids when that's what they are. That's what they are. They're kids. Despite what happened in 1999, despite what happened 5 days ago, they are kids. And I wouldn't be considered anything else at the time that I, quote unquote, committed my crime. I'm sitting in a school building with 1,600 individuals right now from K to 8. And yes, they have a lot going on at home, in the community, and in school. And I want to know why they have these behaviors. That's what I want to know. I don't want to punish them and lock them up in a room and lock them up with chains on their ankles or anything like that. I want to know why. I often have those conversations. How can we build a relationship so that we don't disrespect each other? And I find sometimes this task force is very disrespectful. I find that the conversations that we're having about our children in the community, because we are adults overseeing these children, are disrespectful. And I am hurt today. So I would like for us to come to a consensus. I would like for us to look at the facts. And I would also like for us to look at the history of how it made these kids, how it turned these kids into the monsters that they are, quote unquote, today, right? Because in 2010 and 2008, when I was charged with my second-degree murder, I decided to go the other route. I decided to, collaborate efforts with community organizers to make a change in my community. But everybody doesn't have that opportunity or that support. And we need all of us to be that support. That's all I have to say.
Thank you, Ms. Handy. Any other questions or statements, comments? Ms. Davis, I think I saw a hand.
Yeah, thank you. I just think that as Department of Juvenile Services, we need to remember that our responsibility, our duty to the youth of Maryland is to rehabilitate these children. And that is written so many places in DJS. I think that charging them in the adult court initially takes away any possibilities or many possibilities or options of that rehabilitation that it is our duty to give to the youth of Maryland. And I want to reiterate what we seem so concerned about, this small number of people, this 11% that Jenny told us about, that will be or may be moved up to the adult court. So our charging a youth first in the juvenile system does not preclude that some of these youth, this 11% that Jenny talked about, may move to the adult system if the courts so decide. So that's just my comment.
Great. Thank you very much. Any other, I'm not seeing any other hands or physical hands going up. All right, I'm seeing some waving here. Senator West and then Mr. Ford.
I just want to say that I feel uncomfortable making a blanket decision that covers all of these crimes. I would feel comfortable dealing with some of the crimes and making a blanket decision on them. But it seems to me we should be able to differentiate the very serious crimes from the less serious crimes. And it's hard for me to imagine that if someone's accused of first-degree murder, that the state's attorney is not going to waive it up. I don't know why we would require the extra hassle of and the time that's involved in letting the person stay in the juvenile facility and delaying things. I just feel uncomfortable lumping them all together. So that's my statement.
Mr. Ford, then Ms. Egan.
Yeah, thanks, Glenn. So yeah, just wanted to also echo Ms. Davis' sentiment about, the focus being on rehabilitation. And it seems what happens frequently is that we like to prop up like these isolated incidents. Delegate Pippy brought up the riot at a facility, but still overwhelmingly, that is not the case at juvenile facilities. Again, I think I have a tremendous amount of trust in Secretary Abed and his ability to provide a safe facility for youth who have committed crimes. And Ms. Egan has said throughout this council that we need to move away from these punitive approaches when the data shows that when you take a punitive approach, it doesn't make communities safer and it doesn't help young people. So the only reason that we want to charge a young person as an adult is to make the consequence or the punitive approach stronger. But it doesn't work. The data has shown that. They go there, they get victimized, and they also learn how to commit more crimes. So the focus has to be on rehabilitation and providing youth with the services and supports and the mental health supports that they need. I mean, that's been the fundamental argument from the beginning. Thanks.
Thanks, Eric. Ms. Egan?
Yeah, thank you, Chair. I would like to make a motion at this time to vote on recommendation number 1.
Is there a second? Senator Carter, sorry. I think I saw your hand go up.
Yeah, second, sorry, I couldn't unmute. Second.
Great. Discussion on that motion. So do we, I'm trying to bring it up right now. This is a motion to approve an end to all automatic charging. All kids should start in juvenile court. Mr. Schellenberger, I think I saw you with your hand up.
The only thing I wanted to add is, Nick Browning is now going to be sitting at the Hickey School for a year. And, there's a lot of people who live nearby there. So if you want to keep murderers there, then I guess that's going to be a vote for you.
Any other discussion? I can't see everybody anymore. I'm flipping around here. Ms. Egan, I see your hands up. Is that still from your motion?
Yeah, I just didn't take it down. Hold on, I'll figure out how to do it.
I see no other discussion then. Jamie, how do we move forward here? Does you want to go roll call?
Sure. So this is on item 1 from the OPD recommendations. We'll start with Senator Smith.
Yes.
Senator Carter.
Yes.
Senator West.
No.
Delegate Crutchfield.
Yes.
Delegate Pippy.
No.
Shocker.
Secretary Abed.
Mr. Chair, real quick, to Rosemary King, we're talking about professionalism. You think that's appropriate?
No, and I apologize.
Thank you.
Secretary Abed.
I abstain.
Ms. Egan.
Yes.
Judge Stamm.
Sorry, couldn't get my unmute off. I abstain.
Ms. Douglas.
Yes.
Dr. Sickman.
Yes.
Mr. Bayless.
Yes.
Deputy Commissioner Sullivan.
Yes.
Mr. Schellenberger.
No.
Ms. Davis.
Yes.
Ms. Mandel. I'll come back for Ms. Mandel. Ms. Handy.
Yes.
Ms. Chapman,
Yes.
Ms. Johnston,
Yes.
Mr. Ford,
Yes.
and Mr. Chair, before I get to you, was there anybody that I missed?
Did you have to come back to one?
Oh, that's right. That is Ms. Mandel.
Still no response there?
And I don't see.
Yeah, I don't see her on there now.
Dropped out of the meeting.
Great. And I'll abstain as well, Jamie.
Okay. Let me just do a quick count. That's 13 affirmative, 2 no, 3 no, and 8 abstentions.
And I'm sorry, you broke up on the abstentions.
It's 3 abstentions.
Okay. So that motion carries. Is that the numbers we needed, Jamie?
Well, it is a majority of the members that are voting. So yeah.
Great. Thank you. Any other discussion? One of the things that
I'm sorry, Glenn. Jamie, you said the number of people who are voting. You mean on the commission or who are here today?
Who are here today? Well,
how many are on the commission?
That's 29 on the commission.
Well, 13 isn't a majority. I mean, it's not even half. Is that how this works, Glenn?
I defer to Jamie. I thought that it had to be over 50 of the commission. Isn't that what we researched last year, Jamie?
Yeah, that's it.
You know, I don't remember specifically from last year. I thought I'd have to look back, but I'm pretty sure it was a majority of those voting. But that would be
the open meetings manual says it's the majority of those voting. I think that Secretary Abed may have researched this with AG or reviewed it. So I just asked DJS if they had done any review.
Actually, I did not review it with the AG. We did discuss it on our committee with DLS, and I made the decision in that particular vote to strike it down, and I did use the I guess model of the total number of people in that vote. I will just say that was my decision as the chair. I was not following any legal advice there. I believed that I had the option, and that's what I did.
Thank you, Secretary. If everybody's comfortable with it, what I will do is circle back with Jamie and talk to the AG if necessary to see how that should go forward. Is everybody okay with that? Yes, good. So Jamie, we'll touch base right after this, and then maybe try to get a decision on that, and then bring that back to the committee.
Sure.
Ask a question.
Yes, ma'am.
Is there a process then to collect votes from those that are not attending this meeting?
Yeah, we'll have to look into that as well. I'm sure that we can reach out to them directly.
They didn't see the presentation. They didn't hear the discussion. That's not how the legislature works. That's not how democracy works.
Well, I know that Pennsylvania's similar task force had a voting process that was not during a public hearing, but the votes of each individual were made publicly available, but they were collected offline.
again, what I'll do is I'll work with Jamie from DLS and circle back with the AG's office to see how we can move that forward.
So I'll just say that I reviewed the open meetings manual from the Attorney General's office prior to this meeting. And my understanding from reviewing it was that once there's quorum, unless the commission or task force has intervening bylaws, the majority of quorum can make a vote for a commission or a task force of this sort. And so I'm pretty confident that the AG is going to come back highlighting that part in the manual and that the majority of quorum takes the vote.
Sounds great. Thank you very much, Ms. Egan. Again, if you guys are comfortable, I'll just review that as well. Not that I don't trust Ms. Egan's review of it and get back to the group. Any other discussion for us today? I know that one of the things that Delegate Pippi mentioned early on was enumerating all of the crimes so that we had a more detailed view on possibly for 2, 3, and 4 of these recommendations, which is something certainly I can ask Jamie and our team here to put together for everybody. And we do have another meeting scheduled. I don't know that we've put it out yet. Is that correct, Jamie?
That's right. We're looking at the 16th right now.
So that we would be able to, ahead of the 16th, get you the enumerated list. And Ms. Egan, if you're comfortable, maybe we could work with you in your office to make sure that we're framing it the positive, the way that you would want it to be framed. Get that to everybody so that we can have discussion at our next meeting on 2, 3, and 4. If everybody's comfortable with that, I will also work with Jamie and again the AG and just circle with them on this vote. I'm sure that Ms. Egan is accurate, but we'll just double check to make sure and go from there. Any other questions or statements? Hearing none, I'll take a motion to adjourn.
So moved.
Thank you, Mr. Ford. Second.
Second.
All right, thank you, Ms. Davis. All right, thank you very much. I don't suppose there's any